Petitioning for your own bankruptcy is not as daunting as you first may expect. The first step is to seek independent professional advice to ensure that bankruptcy is the best option available to you. There are many other insolvency options which you should consider with a licensed insolvency practitioner in order to determine the best course of action for your individual circumstances. Assuming you've taken professional advice, the next step is to download and print off the petitioning forms from the Insolvency Services website. The forms you will need to download are forms 6.27 and 6.28. Form 6.27 is the actual petitioning form, but you can complete this at your local county court with the bankruptcy clerk. Form 6.28 is the Statement of Affairs, which you will need to fill in with all of your personal details, including a description of all your assets and liabilities. This form also requires you to provide details of your family's monthly income and expenditure. This particular section is very important because it will be reviewed by your trustee to determine whether or not you have any surplus income. If you do have any surplus income, you will be expected to pay that surplus income to your trustee for 3 years. Accordingly, you may wish to discuss this matter with a licensed insolvency practitioner. The final step, once you have completed your form, will be to contact the local county court to book an appointment to petition for your bankruptcy. Not all county courts deal with insolvency related matters, and if your local court doesn't, they will be able to advise you of the nearest court which does. The cost of petition for your bankruptcy is £705. However, this can be reduced to £525 if you are on certain benefits and meet the qualifying criteria. It is always best to discuss this matter with the bankruptcy clerk to see if you qualify for the reduced fee. On the day of your bankruptcy hearing, you will have to attend at the bankruptcy office and hand the completed forms to the bankruptcy clerk together with the appropriate fee. It is unusual to have to see a judge because generally the clerk will ask you to come back in half an hour or so, and the judge will have made the order in between his other engagements. You will then usually be contacted by your local official receiver's office within 24 hours. The official receiver will wish to ascertain whether there is any urgent action that they need to take. For example, if you have assets that need to be safeguarded. However, the main purpose of the telephone call will be to book an appointment for you to attend at the local court for an interview. This is nothing to worry about and is simply an opportunity for the caseworker to meet with you and discuss any key issues regarding your case, such as surplus income, dealing with your home and any other matters. After the interview, in the vast majority of cases, there will be very little further contact with the official receiver's office.